let's move on. We've got a email question for us, and guys, we can put that up. I was working on a rig and slipped on a wet floor in the kitchen. I broke my arm and had to be sent back to shore for surgery. The company has given me a hard time about paying since I wasn't on the clock when I got hurt. Is this a Jones Act, Kenny? Josh, great question from Kenny. Something real typical what we've been talking about all night. What would your advice be?
Absolutely. Thanks for that email, Kenny. This is a great question. And the answer is, it probably is, if this was a vessel that you were injured on. You said that it was a rig, and a rig can be a fixed platform or a floating vessel that's producing oil and gas. And so if it was a fixed platform and you were a member, if that's where you went to work every day, then you wouldn't be a Jones Act seaman. You would probably be covered by the Longshore Act. But if this was a vessel, then yes, you would probably have a Jones Act claim against the owner of that vessel and your employer. One of the other things to talk about too is that the vessel owner has a responsibility to provide what's called maintenance and cure, regardless of fault. So if you have an injury in the course and scope of your employment and no one's at fault, but you have this injury, the company still has to provide you with the medical expenses to fix that injury. And up until the point you reach what's called maximum medical cure, which means to the point where the doctors can't make you any better. And so that remedy is in addition to a claim under the Jones Act. And it could be separate from. If there is no actionable negligence, there still could be a claim for maintenance and cure.
You brought up something, a rig. Now, everybody in the Panhandle who does any type of offshore fishing, they love to run to the rigs and they love to fish the rigs. And those things are massive. I mean, you have itty bitty ones and then you have really, really, really big ones, and it's just a engineering marvel, to say the least, if you ever get an opportunity to see those things in person. But a rig, some of these things are movable, some are not. Are some rigs under the Jones Act and some rigs under the Longshoreman Act?
That's true. A lot of rigs, the big question is it a fixed platform? And most of the rigs you see out in the Gulf of Mexico where you go fishing are usually fixed platforms in shallower water. When you see the rigs that are way out there, you're going to see some floating rigs, and those are usually governed by the Coast Guard, have licensed captains that pilot these rigs, and those are usually your vessels. But again, the ones that are closer inland and shallower water are usually fixed platforms. And there's also a thing called a jack-up rig, which is a hybrid. And there's some case law out there about whether hybrids are vessels or whether they're fixed platforms. And so again, every one of these cases is highly dependent on the particular facts and circumstances that are presented at that time.
Because Josh, when someone has an injury on a vessel, on a rig, on a fixed platform, whatever it is, more likely than not, the injuries are very significant and severe, unlike a minor fender bender where both parties can walk away and maybe there's just minor property damage. It seems like a lot of these cases where someone gets injured, they're severely injured. So it's really important what area of the law they fall under, what their remedies are, and it would totally determine the outcome, obviously.
Absolutely.
So, I'm sorry, go ahead.
The heavy machinery, the heavy equipment lends itself to having severe injuries, unfortunately. And that's why it's so important to consult an attorney right away in the event of some sort of catastrophic injury offshore.